Hold on. You have the right to remain silent. You have the right to remain silent.
Sure.
Exercise that
Okay,
right.
okay.
Because I don't want you to say something that's going to hurt your case.
Good.
Okay? And the problem is that you never, ever once have appeared on your own in the dozens and dozens of charges that you and I have had together, have never once on your own appeared. Laura. Hi.
I'm approaching Orlando Areola. Yes, I spoke with him this morning and he informed me that he had a warrant for Comal County resisting arrest once this case finished. So they picked him up from jail, took him to Comal County. He was there and didn't finish Comal County until this warrant popped up. So he's never been out of jail. And I had Stephen look.
There was a hold from Comal County placed on May 10th. The hold was released. I did not see.
They never came to get him. They're not going to come get him for resisting arrest out of Comal County.
I don't know where Comal County.
So what happens is, like, when we get someone, I've got a guy who's got 4 charges. He's wanted out of, let's say, Corsicana.
Mhm.
Corsicana has 10 days to come get him here. If they don't come here within the 10 days to come
They
get him,
release him.
my feeling is that's what probably happened with Comal County. They wanted him for that resisting arrest in Comal County, but because they never got him, he was released. But that doesn't take care of the warrant. The warrant's still out there and will always be out there, and he'll continue every single
It doesn't
time.
show a hold anymore. It is gone. And I believe he is convicted on the motion that he was convicted of that resisting arrest. Well, whatever it was.
Alex, can you run an NCIC? please?
Yes, Your Honor. So I see out of Comal County, I see the interference with the public duties charge, the resisting arrest charge, as well as an assault of a peace officer judge charge.
Oh, a 3rd-degree felony assault of a peace officer?
Second degree, Your Honor, yes.
2nd degree. Is it open?
Yes, Your Honor.
Oh, Areola.
It should.
This is one of those people one of our friends that we have here that continue to come back with cases over and over and over. And I told him every single time from now on, we will start doing DDRP until the trespasses and all those things stop. Now, though, he's picked up these cases in Comal County. Can we do this? Can we reset it for a couple days? Do you mind reaching out to Comal County, seeing what's going on? Are they really open cases? What do they want to do? Because we can't do DDRP
Right.
while he's got all these open charges. So I don't know.
I can check the district clerk, the clerk's website, Judge, and for Comal County, and see if there's open cases right now that have been logged by the clerk, and then I can reach out to them today.
That's what I was going to say. If you can reach out to the DAs and see, hey, what's going on? We've got him here. Do you really want him? Is it something serious? I mean, maybe it's something that they just.
I'll let them know that we intend to put them in DDRP over here, and maybe that'll.
There you go.
Okay.
A
So
lot of
Monday-
times that really helps.
That's fine. I'm gonna
Okay.
call them today.
Okay.
So,
And then, so just let them know how the plan here is we will continue to do DDRP.
you said, so the exact offer from the court is what, a 2-year probation and then sending them.
Oh, he's on probation now. We went to trial.
This is a trial case.
We went to trial. He lost because he didn't want to accept the DDRP. And I said, we're not doing anything.
Okay.
And so we went to trial. He lost. I sentenced him to like a year with
180 days probated for 20.
No, maybe he did take it. We went to trial on someone else.
Yeah, I don't see an actual.
There's someone else with the exact same,
Right.
we've got maybe like a handful of these, right?
It looks like he entered a guilty plea.
Okay, so,
Your Honor, just clarify that he was released to Comal County. They came and picked him up on the 16th of.
so he's gone.
He went, after we took the plea to put him on to do the probation, the hold came on the same day. They came and picked him up on the 16th and went to Comal County. Now, he's saying he never was released from Comal County. He got brought back here on this warrant, so he's never been
Oh,
out
got
in the
bench
free to do the probation.
He never, I guess, ended up doing anything over there. They just got bench warranted over here.
Mhm.
Okay, so now we know. So I guess, yeah, reach out to them, tell him what our intentions are. Let's see how serious they are. And if they're, out for it, then I guess what we'll do is we'll allow him to bench warrant him back over there, take care of that stuff. And then we're just going to keep our hold and then we'll bench warrant him back when they're done.
Okay.
You should.
Yeah. Thanks, Lori. So Amala juice creates new hair. Is that what I'm hearing? Is that true or not? Well, we got an email saying that Amala juice gives you more hair, a significant amount of hair to where now you can have long hair. I'm gonna show this to my wife.
After speaking with my client again, he says that he received PR bonds on those cases in Comal County without a future date. And he is concerned about waiting to see asking, he wants me to ask you to lower his bond if he could get his bond lower.
Bring out Mr. Ariola, please. Let's talk to him. I was just, Lori, talking with Victoria that someone sent me an email that I can get new hair if I drink Amala juice. So I'm gonna take that and maybe we'll give him a PR bond and we'll all be happy. Good morning, Mr. Ariola. Good to see you. I'm sorry that we're seeing you under these circumstances, but you've picked up some serious charges in Comal County. And the problem is that you never, ever once have appeared on your own in the dozens and dozens of charges that you and I have had together, have never once on your own appeared. And you want me to give you a PR bond? Tell me.
I'm asking, give me an opportunity to present myself or report myself to the probations that you've acquired my person to. I've been back and forth between Harris County and Comal County since the last time you released me. I never gotten a chance. I just now came from Comal County back over here. I'm asking for to give me the opportunity that I may be able to
Report on his probation, Judge.
yeah.
And based off what I am looking, it appears that these Comal County cases happened prior to him being placed on probation. So they wouldn't necessarily be a violation of his probation.
Alex, what say you about the time?
He was placed on probation, it seems in May, if I'm correct. Is that correct?
May of 2024.
These Comal County cases, they took place in July of 2024 and subsequently filed that same month. So July, so after he was placed on probation.
Mr. Ariola,
I was in Comal. I was taken from here to Comal County. Okay, prior when you gave me that, I was out. That I was able to.
I think I know what you're trying to say. He's saying he has never been out of jail to commit these cases in July.
but he has been. You were out.
If I may,
You were in aftercare, and it was probably at that time when you picked up the new cases.
it's the same. If I may share with you, these cases are the same cases or the same circumstances, just as the trespass.
I know. And I know it keeps happening over and over and over. They try to pick you up, you don't like it, and it hits the fan. And then you end up picking 3 to 4 charges as every single time this happens.
I'm not a criminal, nor am my intention is to do crime in the world. That is not my way of living. That is not my way. What I'm at this moment right now, what I'm seeking, what I'm asking is to get the opportunity to be able to report and to do as you asked for the probation.
Let me tell you one thing, okay? Hold on. Since 2021, you and I have been dancing. You've picked up an attempted possession of a firearm, possession of a controlled substance, possession of a controlled substance, failure to ID, resisting arrest, failure to ID, failure to ID, failure to ID, evading arrest, criminal trespass, criminal trespass, criminal trespass, possession of a controlled substance, failure to ID, criminal trespass, criminal trespass, criminal trespass, criminal trespass, criminal trespass, criminal trespass, and another criminal trespass. On all of those, except the last 2, every single time you have done time served. And I told you on the last 2, before you picked it up and we let you go, I said, Mr. Ariola, if you pick up another case, we are done with catch and release. We will now do everything in our power to ensure that the trespasses and the failure to IDs and the thefts and the assault stop. And we would do that by doing the dual diagnosis residential program. And I told you that we would continue to do it over and over and over until it stops. You know what's going to happen every time you wear orange in Harris County. That's it. I have given you PR bond after PR bond to the tune of probably 12 PR bonds. And every single time we've given you a PR bond, you never show up. No more catch and release. We now need to get to the root of the problem. That's what we're going to do. And even if we have to do DDRP 5 times.
Listen, let's be honest. If I was to represent myself, it's stick to the grounds of laws, of real laws, of what's contributing to what's to myself being, my well-being, my person, the person that you are treating in such a way at this very moment. It will be a different story and a different face for you, my friend. I'm only talking here.
Stop, that can be considered as a threat. I am just giving you fair warning.
I want to help you, Mr. Ariola. I want to end the cycle of you keep coming back to jail. Believe it or not, I want to help you. I want to end this. I want you to get a job. I want you to be a productive member. And I was hoping by having you go to the DDRP and in aftercare, that would happen. I don't know. I don't know what happened. You were doing great in DDRP and we got reports that you were doing great. When you got to aftercare, I don't know what happened though.
At this moment, the charges from Comal County, I'm on PR bond. They haven't even been, and I haven't even been indicted. At this moment, I'm asking that I'm given the opportunity to complete this program of yours. Let the service play as it plays. There's a whole different county, a whole different jurisdiction.
Let me give you a little roadmap, what I was thinking. I'm having our chief district attorney here reach out to Comal County to let them know what we want to do here about DDRP in hopes that they, are on board with us.
They have nothing to do with y'all. There's a whole different
I know.
Jurisdiction, a whole different county.
I'm trying to let them know that we want to put you in a treatment place with us here in hopes that they're with us. And it may resolve the cases over there. See what I'm saying?
I'm on a PR bond over there at this moment. Why would they care what happens here? They don't care. They're just on for how dare? What idea is this from?
I can let Lori explain to you what we're trying to do.
I'm listening. I did hear it, but this.
So Ariola, if I give you a PR bond, you'll never come back.
I'm not asking for a PR bond. I'm asking to give me the chance, the opportunity to report to the probation that you put me on. Give me the chance.
Yes, I want to do that. We are,
Please.
yes, I am in agreement with you. But first, Como County has to take care of itself. We can't do anything here until Como County's taken care of.
People, Comal County sent me over here.
I know. We're going to reach out to Como County to see what we can do.
They got me on PR bond over there so we can take care of the situation over here at this time. This is what I'm doing here now. They got no business into what Harris County does with me at this moment, with this case here. They have no business. They haven't even indicted me yet.
I'm going to let Lori try to explain to you what we're trying to do.
But you're trying to, I know that, why would you even want, listen, you're the judge here. You know what's going on. I'm on PR bond over there. They're not even looking at my cases at this very moment.
What do you want?
I'm asking, give me the opportunity to report to probation now. Give me the opportunity, because I haven't given the opportunity to report to probation.
When you say give me the opportunity, what does that mean? Let you out of jail?
Yeah, so I can report to this, and when Comal County, because I got a lawyer over there, they would alert me about going to, if they do pick it up, if they do pick it up, they would alert me to go to court. But till then, let me just proceed with the process here with the probation. Please, that is what I'm asking. I'm begging for you, so I can get an opportunity, a chance to get out and work and be able to fight this from the free world. If anything, if they do pick up the cases, I'll be able to fight them, so I can stay relevant to the probation here and current with Harris County.
I know that you're not going to like my answer, Mr. Ariella, but if I give you a PR bond, you're going to ghost me like every time you've done before. I have history tells me I have your bonds now always at 2003, 7504, 5006, because you take off. You never in 5 years, you've never not one time come back on your own.
Why would you give me a PR bond? Can you just not reinstate me to complete the probation? I haven't even.
Anything, we need to figure out what's going on with Como County. I'm going to let Lori hopefully try to explain to you what we're trying to do with getting Como County on our side as well, so that hopefully we can resolve it all. And
I don't know if this is even, like, would you even really care to understand what Comal County, being in Comal County, what it has done to.
Let's do this. Look, I have a bunch of people that are waiting. I'll take more time with you toward the end of the day. I don't want to keep them waiting because they have busy lives as well. Let me talk to them. Let me thin out everybody here, and then I'll bring you back out and we can talk more. Okay? But we've already spent, 20 minutes here now, and I've got a lot of people waiting. Let me thin them out. I'll bring you back out in maybe like 45 minutes and we'll talk more. Okay? I'll give you more time. I promise. Counsel. Thanks for being patient.
Just on page 2, Albio, results came back positive for THC. Do you want us to?
Yeah, let me talk to Mr. Ariel first so we can get Lori out.
English judge, he discharged on the 23rd. They had him come on the 24th.
Okay, hold on a second. Mr. Lopez, you asked me for a PR bond now. I'm sorry, Mr. Lopez, Mr. Ariola. Sorry, that was Mr. Lopez. Mr. Ariola, you asked me for a PR bond, but let me tell you something. Every time we let you out of custody, you have little wings on your back and you take off. You did the program. You did it amazingly. All we wanted you to do was do the aftercare. You were supposed to report. Your date of discharge was April 23rd of 2024 of the program that you were in. You were supposed to report. Oh, is it the same day, Shatoria?
No, it was the next day.
I'm sorry. The date of discharge was April 23rd. The next day, you were supposed to report to the place for aftercare. Did you report? You did not report. And you took off yet again. Every time we let you out of jail, you do whatever you want to do and you don't comply with court orders. So I can't trust you and give you a PR bond now or reinstate you. We're going to work the way through that we normally do. We're going to see what Como County wants to do. And then after that, we're gonna go right back into SATA. Tell me.
I'd like the court to consider my position of not having the opportunity to report myself on the last, this,
Judge, I'm sorry. I feel as though we're talking about things alleged in the MAJ. I don't want to be unfair to the defendant at this point.
Counsel's here.
Oh, she is here.
Yeah,
Okay.
she's on.
Okay.
No. We're not gonna do this without counsel. No, Michael, come on. No. She's here.
Yes, Judge.
as I was saying, to consider the position that I was put in, not given the opportunity to present myself, report myself to the probation office.
We let you out. You were supposed to report. Is that not a chance?
That was a different, that was another,
Case.
another. The one that I'm asking of, that I was in current in agreement with you, was the probation that came with the counselors.
I don't want to go on a 30-minute diatribe, a 30-minute conversation again, Mr. Ariel. The bottom line is if I let you out, you will not show up to anything that you're supposed to show up. And I have it as evidence in every single case that you and I have dealt with. Every single time I have let you out, every time that a magistrate has let you out, you take flight and you take off and you never come back.
I'd like to resolve this issue, this matter.
I'm not, sorry. I'm not going to do that. I told you I was done with the catch and release. It's not going to happen. We will continue.
I'm asking for my time for these cases that I stand before this court today.
Okay. Regardless, we can't do anything now because you've got the Como County cases open. So I'm going to have the DAs reach out to Como County to see where we go from there.
Judge, he also said earlier that he would like a hearing on these new charges in Comal County.
Say it again.
He would like a hearing on the new charges in Comal County, because we're not sure whether or not the state can prove them.
Judge, if there was a hearing, we would put up the technical, we wouldn't put up the new law.
They're not putting up the new law violations regardless. I mean, they're not going to do that to kind of hurt Mr. Ariola even more, you know? So I don't think that would be part of the motion to adjudicate hearing. That would hurt you more, and that's not what we're here to do.
Those Comal County's charges are allegations. I'm still innocent
Correct.
and haven't been indicted yet.
Correct.
I'm confused.
I don't know that.
I'm confused on what.
There is a hold at a Como County, right? Vic?
I came from Comal County. I bonded out on.
I have 2 bonds on your case, and because you were unable to make the bonds, that's why you're still in custody now. I'm not giving you a PR bond. So we also need to find out what's going on with Como County. So bottom line, Mr. Ariola, I'm not letting you out today. Okay? We just need to work the thing to see how it plays out. And then
I'm asking that the court stays within this district. Comal County is relevant at this point. I'm still, there are allegations.
we're not using any of that. None of that is being held against you, Mr. Ariola.
And Judge, for the court's information, the updated hold information is that they released the hold on 5/16 of 2024.
Okay?
So currently, there's no hold that the state can see.
Okay. Can you reach out to them to
Yes, sir.
see and let them know of our intent here? And then, when do you want to set it again? Today's Wednesday. Try Monday, maybe?
You haven't said
Okay, Judge,
the
I'm gonna
court,
reach out
yeah.
to them.
Okay, we're gonna try to do this fast on your behalf. We're not gonna take a long time to do it. I need them to reach out to Como County to see what Como wants to do with your 3 cases. We'll come back on Monday and we'll see where we go from there. Okay, Mr. Ariel, I'm not letting you out. I know what's gonna happen if I let you out. I can't do it. Okay? I know that you're upset, but believe me when I'm telling you, I want the best thing for you. Okay,
I'm having a hard time to understand.
I don't, I'll
Yeah.
have Lori explain it to you, okay?
That's okay.
I want what's best for you, Mr. Ariola. I think that this is it, okay?
To keep me in your program? To keep me in your pocket?
Not in my pocket.
Mr. Arroyo.
Yes.
I want you to answer this honestly. When a person completes treatment, shows real progress, and then vanishes the day after they walk out the door, is that a failure of the person, a failure of the program, or a failure of the system that released them with nowhere to go and no one waiting on the other side?
Put your hands in your side.
Mike, I see you.
Dan, great to see you. What's new?
Judge, this is a plea. It was a felony case. We refound it as a misdemeanor.
Okay.
And there is a victim impact statement. The victim is not present. So I was wondering what the court wanted to do.
I
In terms
don't
of
want to do it. If they want to make a victim impact statement, then I want them here and we'll do it all together at the same time. Because I want that person heard as well. It's only fair. So,
They were unable to make it today. They had notice about today's court date.
fine, we'll set it for whatever day you want. Do you want to reach out to them to see what day is good for them and then we can do it? I mean, take your time. There's no rush.
Judge,
Really.
if I may, this case is 3 years old. We've had 7 trial settings. We finally resolved it to today, and then she can't come on the day of trial.
I don't know, Joe. I'm
So
just.
that's what I'm saying. I'm letting the court know. I think that's kind of unfair to
See
my
if they can
client.
Zoom, because I have Zoom.
We could ask her. I don't know if she has that ability.
You want to see? Can we stand down for a bit?
I'm sorry.
Just,
Stand down to see if she's available to
she
Zoom.
is okay with someone from our office reading it in her place, if the court's okay with that.
It's the whole purpose. No, can you reach out to her real quick and just see? I know you're in the home stretch, Jim. I mean, I know you've gotten a great deal here. They're reducing it to a misdemeanor, getting on it deferred. So just give me 5 minutes. Let me see if they can do that.
Yes, sir.
A few moments later.
So, guys, please keep it down. If you need to talk, go outside. We have someone that's going to testify here on Zoom. No talking. Ms. Echevarria, can you hear me? So,
Oh, hello, can you hear me?
yes, I can hear you.
Okay.
Okay, give me 1 second, ma'am. Give me 1 second. So procedurally, with this case, Joe, he gets charged with a sexual assault upstairs, or he's on bond for a sexual assault,
Come on.
and then he picks up an indecent.
No. Plea bargain down to a class A indecent assault.
The felony court does not do misdemeanor probations, so we had to refile it as a misdemeanor. That's what the plea deal was, essentially.
So it was a reduction to a misdemeanor,
Correct.
indecent assault,
Correct.
to a 2-year defer.
Correct.
Okay. So let's do ma'am, what I was going to do is do the plea first and then have you say something after the fact, if that's okay. Are you okay with that?
Only if it's not allowed for me to speak first prior to the plea, then of course, yes, it's okay to speak
If you want to
afterwards.
speak first, then you're welcome to. Is there
Okay.
something that you wanted to say?
Well, I wanted to read my victim impact statement.
Please do. You're welcome to do it.
Okay, thank you. Okay, so I'm writing this statement to share how this experience has continued to affect me long after that night. There may be times where I actually need to take a moment to breathe, actually. Just wanted to go ahead and say that first. When I first submitted this statement, I was overwhelmed. I was still in emotional shock and unsure of what to say and how to say it. I've since come to understand the importance of expressing clearly, not just what happened, but how it impacted every part of my life. This event has completely changed me. I wake up with anxiety. I experience episodes of fear, confusion as to why I did not run, and constantly feel a loss of trust, not just in people, but in places I once felt safe and in myself. Every day I'm reminded of what I've lost. I lost peace of mind. I lost the ability to work without panic, the ease of everyday interactions. Every day I'm reminded of how I got taken advantage of and didn't react as I felt I would have in a moment like this. If this emotional toll has affected my professional life, my relationships, my physical well-being, I can't control my heart rates in these moments of panic. They are true anxiety, full-on panic attacks that I experience still to this day, 2 years later. At the time of my first statement, I didn't have access to important documents, which are records that might have helped me explain myself more clearly within these 2 years. Since then, I've started the process of requesting my full case file from multiple agencies, medical records, and forensic testing. I have not received those as of today just yet, but I know those documents all exist. It's been over 2 years, and this case has been reset multiple times. A new prosecutor was also assigned only days before this plea was suddenly brought to me. The rapid timeline did not allow me to revise my statement or consult with anyone about how this offer would impact my rights as a survivor or my potential ability to seek justice outside of this criminal court. This statement is not about vengeance. It's about the truth. It's about my healing. It's about ensuring my voice is heard in a process that often feels designed to just move forward without it. Every day since this assault, I've struggled with anxiety, flashbacks, and trust issues that have reshaped how I live my daily life. I still cry regularly from this incident. I still shut down. I still replay everything from the pressure, the coercion, the force, the aftermath of where I try to survive it all without falling apart. And yet I still feel like I have to justify why it broke me. This wasn't just a violation of my body. It shattered my trust, my sleep, my ability to feel safe in my own skin. I've spent nights replaying what happened, and the fear and the disgust and the betrayal. What was taken from me was not just physical, it was psychological and it was spiritual. I'm a hairstylist, and my career is built on one-on-one trust with my clients. Since this happened, I felt constantly on edge with male clients. I find myself backing away from simple interactions. I've lost my income. I've lost my confidence and my own safety in my own body. The job I once had, I lost due to being completely disconnected from my mind and my body. I now know that this man was on deferred adjudication and had a breathalyzer in that car, and yet that night he took his mother's car and drank heavily and violated me when I was in and out of consciousness. The defendant slapped my face during intercourse and violated me. His third time assaulting me that same exact night without consent. I remember him begging me again and again, and I kept saying no. But I couldn't get up. I pushed him away off of me again and again. That is not consent. Me freezing up was fear. That was survival mode that I was going into. And Your Honor, I ask that you consider what kind of system lets someone walk away with that and just probation. Even after all of this, I still had to let him drive me home the next day and bought me a Plan B pill. The defense says I had chances to leave, but how do you leave when your body and your brain have been hijacked by fear? The prosecutor told me that juries don't like women and that they don't believe us, and that broke me more than anything. I was told I could be blamed at trial for going to the bar or for texting him afterwards, as if trauma survivors don't respond in ways that help them stay alive. That's why I'm asking you now to please understand that this proposed plea is not justice.
Then I'm not gonna take it. I'm not taking it, Joe. I'm not doing it.
Sorry. Just because you spoke first?
Oh, I mean, I don't know. All I know is that we have a powerful victim impact statement here. We have a sexual assault is being reduced to a misdemeanor, 2-year deferred.
Correct.
Apparently, no one's consulted her regarding this thing, see whether they,
We have been in extensive communication with her this past.
No, sir. No, sir. I
About the plea
barely
and
spoke
reasons
to you
for
a couple of days ago, sir. I didn't even know you were on my case until Tuesday or Monday it was Tuesday when you first called me. I didn't even know Missy was not on my case anymore. And she gave me the confidence that this would go to trial. She believed we had a very strong case to bring this to trial. She didn't have any doubts in this case at all. And I meet Gabe just this Tuesday. And it's rushed into this plea without even without even discussing with me.
Do you think a judge should consider personal circumstances, like family, employment, or age, when making decisions in court? Or should every case be treated exactly the same way?
okay. Thank you, Ms. Echevarria. I appreciate your testimony.
I really appreciate your honor letting me speak before you accepted this plea.
Absolutely, and I'm glad that you were here to speak, get everything off your chest.
Yes.
Anything you need, we're here for you, Ms. Echevarria.
I really appreciate that, your honor. Thank you for letting me get on Zoom, even though I could not physically be there.
Yes, ma'am. I will accept this, but I'll do 30 days as a condition. It's the only way I'm going to do it. So you guys can talk and see if there's
So
something
I
you
think it's
want to
unfair
do.
to my client because normally we do the plea, then we have the statement. Just because she spoke first, now she's gonna bust the deal?
She's not busting anything. I mean,
I'm the victim. I am the victim. How do you even
Please.
speak about? Sorry.
Please,
Yes,
it's
sir.
okay.
He's been coming to every court date. We've been set for trial 7 times. We're actually set for trial this morning.
In the district court.
I'm sorry,
In the district court.
in felony district court.
I get it. She feels like, one of the things that we need to take into account, is I'm not going to do it without 30 days as a condition. I'm sorry, Joe. So you guys can talk or we can set it for trial. It's your decision, Mr.
Can you do home confinement?
Home confinement? No. That's a gift. No,
Can we stand up?
please.
Okay.
A few moments later.
It's only 10 days, just, 10 days. Otherwise he loses his job.
It's better than the current deal from our perspective.
Okay.
Come on.
And also, Judge, the complainant did not finish her impact statement, if she could be allowed to do that.
Yeah, let me do this first. We'll go through with it and then. So, Mr. Camano, I'm also putting on a protective order as of today. Mr. Camano, you're charged with indecent assault. You're facing up to a year in jail and/or a $4,000 fine. The agreement that you have worked out is a 2-year deferred with thinking for a change, sexual boundaries course, 50 hours of community service, no contact with Ms. Echevarria, and 10 days as a condition in jail. Do you understand?
Yes, Your Honor.
Is this what you want to do?
Yes, Your Honor.
You are giving up the right to have a jury decide whether you're guilty or not. You're giving up the right to cross-examine any accusers, confront any witnesses. You give up the right to appeal. Once you accept this agreement, you can never get out of this. It will continue until you complete this agreement or if you violate it. If you violate it, I will issue a warrant for your arrest. I'm going to bring you back over here. We are going to have a hearing whether you violated this. And if you do, you're looking at an entire year in jail. Do you understand?
Yes, Your Honor.
If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law.
He's a U.S. citizen, Judge.
Okay. How do you speak for the offense? Guilty or not guilty?
Guilty.
I'm not going to find you guilty. I'm going to withhold that for 2 years. You will be required to do the thinking for a change, sexual boundaries, 50 hours, community service, no contact with the complaining witness, no weapons, no drugs, alcohol, random testing. I want him tested in a week, please. If you're using, it's not going to go well. I'm going to tell you now, I'm going to test you like crazy. If I find that you're using, you're going to get a one-way ticket. Do you understand?
Yes, Your Honor.
Okay. Ms. Echevarria, did you want to say something else?
Yes, I'd like to finish my statement, please.
Okay, you may continue, ma'am. Shh.
Okay. Sorry, let me get back. Okay. I was 2 years of okay. So I have submitted requests to the HPD, Houston Methodist, and the Forensic Center to access police reports, my toxology, and my rape kit results, all things I should have had years ago. I just began accessing public records on my own because no one helped me understand I had the right to review them. And this is why I wanted to request a continuance. I do respectfully request that the court do require the conditions that prioritize accountability, rehabilitation, and safety, such as formal admission of guilt in court or via stipulation, no contact, and geographic restriction order, mandatory sex offender rehabilitation, and language in the plea agreement affirming that I reserve my right to civil litigation because I want peace and I want to heal and I want to know that my voice mattered. Also, Your Honor, I respectfully request that you do not proceed with that plea until I have had the chance to review the full case file, as well as all the evidence I'm lawfully requesting, including the police reports, toxology, and stain results. I was not given the sufficient time to revise my statement, and I've had to teach myself how to access the court records after being left out of the process. This case was reset 7 times in the past month alone, and I was promised a trial, not a rushed plea. I'm asking that the record reflect my objection and that my request for a continuance be considered on the basis of my rights under CCP 56A.051 and 56A.052. If the court must move forward with that plea, I would request the formal admission of guilt, the no contact order, required sex offender counseling, and a clause affirming my right to pursue civil litigation.
What I will say, ma'am, I know that you are upset, and I'm sorry that you are. I have no idea why it ended up here, but it is. The lawyers, I think, have been working for a while to try to resolve this. They've come up to an agreement. I did issue a protective order now so that there is one in place.
Thank you.
So, and I've also ordered no weapons as well. So,
Is there any way he can have the sex offender counseling? I feel like very much so.
I don't have, that's not something that I have access to down here. That's only in the felony courts. So I don't get access to any of that stuff.
What about the formal admission of guilt from the defendant?
They have worked out an agreement where they're doing a deferred. So it's a deferred adjudication. That's something that you're going to have to get with the office about. I know that you have other avenues of recourse as well. I can't give you legal advice. The only thing that I would probably advise you is just go talk to a lawyer, you know?
And so trial is not able to go forward.
No, the case is done now. It's ended in a deferred adjudication just now, ma'am.
Okay, and he was previously on the adjudication, but what about, I still feel like I'm being silenced with everything that I've been saying.
The only thing I could advise you is go back to the district attorney's office and just start, talking to people there.
To the district attorney's office?
Yes, ma'am.
Judge, our first trial setting was March of last year.
Just
so you know,
yeah,
I mean, this is the first time we're hearing about her asking for anything. And we've
No,
had
I was not.
setting after setting.
I was not aware. I have all the
Excuse me.
texts of
Can
the.
you finish, please? We've had setting after setting. This is the first time we've heard anything about this from her. So I don't think that's
This is not the first time. I have.
Ma'am, let me
I
finish,
have
please.
requested forms before. I have sent
Well, ma'am,
emails
look,
to get these
Mr. Chevalier,
documents, and
I
I was
don't want to
not
get
granted.
I don't want to get into a big match about what's going on now. The only thing I can say is if you have any kind of disagreements, get back with the office, talk to go to the district attorneys and go talk to them and figure out what else. Like I said, there are other avenues. I can't give you legal advice. I can't tell you what to do from here. Okay.
Okay.
Is that it?
Yes, sir.
Okay. Thank you, ma'am.
Thank you, Judge.
Start the 10-day session.
Can we start next Friday? Sure. That's it. Okay, thank you, Judge.
Will the court allow me to consult the opportunity to consult with the victim advocate
Is there a big?
or a legal liaison
And
before
we have a
anything is
social worker.
finalized?
We have a social worker who is assigned to this case as well, and both of us have been in contact with.
So do you have the number to the social worker, ma'am?
She hasn't been that responsive recently. Just coming up to the court date, really.
Suggested.
I'm happy to give her a call this afternoon and we can go over all of that.
Okay, so the prosecutor assigned to this case will give you a call this afternoon to try to help you get in touch with the social worker to remedy any kind of issues you may have. Okay? If you still have any issues, you can come back tomorrow and then we can try to resolve it further. Okay?
They're at the courthouse.
Yes, ma'am.
Okay, will I be will I be asking for you for your courthouse personally?
You're welcome to, ma'am. Yes. I'm in court 5. You're always welcome to come here and we'll help you out as much as we can. Okay?
Court 5. Okay, and what exactly was the plea that he admitted to, or what is he?
It was a 2-year deferred adjudication.
Joe.
With 10 days in jail as a condition.
Okay, oh, so it went down to 10 from 30? I think I heard 30 earlier, it went down to 10?
Ma'am, I can't continue with this. I have a courtroom full of people that I have to get to. I'm sorry. But I will let you speak, or this afternoon, Gabe is going to call you to prosecute on the case and he can explain everything further to you, okay?
Okay, thank you.
Yes, ma'am.
Valerie, I'll text you as well.
Okay, thank you.
Thank you.
What you just witnessed was one of the most raw, honest, and heartbreaking moments that a courtroom can produce. A survivor, appearing on Zoom from wherever she found the courage to log in, reading a statement that took her 2 years to write, about a night that took everything from her. She talked about panic attacks that still wake her at night. About losing her career as a hairstylist because she can no longer trust being alone with the client. About buying her own medical records because nobody told her she had the right to see them. About learning on a Tuesday that a case she had been promised would go to trial was suddenly ending in a plea, and that the prosecutor who believed in her case had been replaced days before. Under the Texas Crime Victims' Rights Act and Article 56A of the Texas Code of Criminal Procedure, the very statutes she cited by memory in that Zoom window, every crime victim in this state has the right to be informed, to be present, to be heard, and to be treated with dignity and respect throughout every stage of the criminal justice process. She cited those statutes herself. She had to teach herself how to access court records. She had to request her own rape kit results. She had to ask for a continuance because no one gave her enough time. The judge listened. He added 10 days in jail as a condition. He issued a protective order. He told her to come to Court 5 anytime she needed help. And then, because a courtroom full of other cases was waiting, he had to move on. That is the part nobody warns you about. Justice does not always feel like justice to the person it was supposed to serve. And the bravest thing in that courtroom today was not a gavel, not a plea, and not a legal argument. It was a woman on a screen, hands shaking, reading the truth out loud, because she refused to let her voice be the one thing this process took from her.
Thank you.
All right, Judge, next is page 27. Stanley, come on up.
Good morning, Mr. Stanley.
Morning.
So you stand charged with terroristic threat as well. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On Monday, February 17th, 2025, an officer was dispatched to a residence in Harris County, Texas. The complainant stated she was walking her dog and she saw the defendant walking on a sidewalk close to her residence. The defendant began screaming and telling the complainant that he was going to kill her and her dog. The defendant ran towards the complainant and continued chasing her until she ran back to her home. The complainant advised she was in fear for her life. The defendant was located at a bus stop outside of a location in Harris County, Texas.
Mr. Stanley, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with this person. Do you understand?
Sir.
You are also not to be in possession of weapons as well. I will do everything in my power to protect every person in my county by whatever means. If I find that you become a danger to my community, I will lock you up, deem you a public danger, make your bond high. Do you understand?
Sir.
Do you have the ability to hire a lawyer?
It might take time.
You working?
Off and on.
Anything steady or no?
Not steady, off and on.
Okay. You want to apply for an appointed lawyer? All right. So, Deputy Pinson is going to give you an application for an appointed lawyer. I need you to fill it out. I need to know everything about you. I'm going to have you sign a reset with Victoria. We'll have you take a seat in the jury box. Do not leave until you sign our bond conditions. All right?
Right this way.
So can you file no contact, no weapons, no going within 500 feet of where she lives or where she works?
How are you, sir?
How are you? Wonderful. So you have a guy that's in custody, right? You said?
Yes, Your
Is
Honor.
it?
He's in immigration court. And
So
like
you
yesterday, I picked up this case.
do you want, you're signing on, obviously, right?
I'm sorry, say again?
You're signing on?
Yes.
Okay, so because you're on it, because you have this, do you not want me to revoke the bond?
Yeah, I don't want you, well,
I'm okay not doing it.
yeah,
You know, and we can set you for the day after this hearing.
right. His master calendar hearing is set, I believe, March the 11th, and his future is greatly determined.
Sure, of course. Are you representing him in this?
Yes. And
Right.
in immigration.
Great. So just keep us in the loop. The only thing I'm going to ask you to do is if you're able to get him a bond and he does bond out, he needs to be here the next business day for bond conditions.
Absolutely.
After that, once we get him under conditions, we'll waive his appearance until you guys work it out. So
Pleasure to meet you.
absolutely, likewise.
All kinds of stories.
Oh, no, don't.
Most of them, well,
So if you want to do March 12th, I'm happy to do it.
uh,
Or whatever day you want, really. Doesn't matter to me.
probably a few days after that.
Sure, of course.
So,
Yeah, just tell Victoria.
thank you, John.
Absolutely. Help me out real quick.
This is Mary, M-E-R-Y.
You were on bond for theft,
Yes, sir.
and now you've picked up another. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, sir.
On February 17th, 2025, an officer was sitting in a Walmart parking lot and observed a male wearing a black jacket, red shirt, and brown pants running at a full sprint from the front of the store with what appeared to be a large box holding near his waist and trying to conceal with a jacket. The officer shouted to the male to stop running approximately 60 feet away. The defendant stopped, made eye contact with the officer, and entered the passenger side of a motor vehicle. The officer shouted for both occupants to stop, at which time the motor vehicle sped off, exiting the parking lot. The officer was advised by another officer that he was behind the motor vehicle at a Valero gas station parking lot. The defendant was detained and recognized as the same person observed to run away from the store. The complainant, a loss prevention associate, provided video showing the defendant walking past all points of sales with a speaker, total value $289, and the defendant was later ID'd by his Texas driver's license.
He's on bond for a prior assault.
For
Was it-
prior theft, yes, sir.
Right. Was that at the Walmart? And did we order him not to go to a Walmart?
That prior theft was from a Home Depot, Judge.
I can't continue to give you PR bonds, Mr. Mary.
Yes, sir.
You continue to pick up cases. What am I supposed to?
I don't think I'm.
Stop.
Yes.
I'm not asking you to talk. I'm just telling you, I'm not going to continue to give you PR bonds. You're going to stay with me. You picked up a bond while you're on bond. I told you not to pick up any more cases. You've now picked up another case.
Nobody told me anything. The first time was,
Stop. I'm revoking your bond. I'm putting you in jail now. I'm going to appoint your lawyer and we'll talk and we'll figure out where to go from here. But this is the third PR bond now. No, sir.
isn't that 3?
It's 3.
It's not me though. I only have 2.
This is not a negotiation right now.
2.
I will appoint your lawyer. I want you to talk to someone and then we'll figure out where we're going from here.
What is the purpose of a bond condition? And why does a judge have the authority to set specific rules a defendant must follow before
Where we're going
trial?
from here. What's going on?
I'm approaching on Edgar Gonzalez. He's on docket this morning. The reason I'm approaching Judge, if I may, is he is currently on bond conditions, so there are no violations or anything, but random urinalysis is one of them. And he had scheduled a cruise before this case ensued, and
I don't have a problem with him going. He just can't use.
yes, Your Honor. I'm sorry. No, I just don't want him to be.
So what we'll do is we will,
During that week.
right. What we'll do is just let Felicia know the dates that he's going.
Yes, Your Honor.
Let us know he's going to get tested as soon as he comes back.
Yes, sir.
And the tests go back a couple weeks, so we'll be able to see if he's using. So tell him I know that he's going to be a big constant party, but that doesn't, give him the authority to use. So please tell him not to use. The other thing is they've also filed a motion to amend in this case. Have you seen it?
I saw that. Yes, sir.
Okay.
Do you have any objection to it? I think they're amending.
Other than we're splitting hairs because it's right at 0.15.
Okay, all right. Thanks. So Felicia, just, if you don't mind getting the dates, please. All right. Okay, thanks.
Good morning.
Hey, good morning.
Judge, I've got a brief off document, if I may. Got a cause number whenever you're ready.
Okay.
253-5924. It's my client, Joe Greathouse.
Okay.
Judge, Mr. Greathouse has a scram of check with pretrial. He's had no issues. He's in compliance. He drives for a living. He's got a truck that he wants to finalize getting. He's pre-approved for an insurance policy. I'm asking if the court would consider switching the tram to an in-car so he can drive. That would be his only vehicle.
What do you think? He also has an FSRA upstairs and an evading arrest in a motor vehicle.
It's up to your discretion, Judge. Obviously, I don't see what the harm would be of keeping the scram on.
Is there no driving right now?
No, there's not a no driving. You just can't drive without an interlock equipped, I assume.
He's going to put it in the work truck?
Yes.
Yeah,
It's his
okay.
only vehicle.
All right.
Thank you, Judge.
Just let him know it's not drinking.
Yes, Your Honor.
It's not going to go well.
And he's been doing treatment for about a month and a half, 2 months now. Yeah.
Counsel, is he here today?
No, he's not.
Mr.
It might be under Santiago Lopez in your docket. He has two names. But it's July 2nd, yeah.
It's not Santiago. Let's try Lopez.
Yeah. It's under Lopez Santiago Art System. I can give you a cause number.
Yeah, I'm gonna need it because I don't even see it. All right, what is it?
252-7146.
It's an Myrna.
Right, so for some reason it has one in your system and one in them.
I don't even see Myrna. It's on today?
Yes, Judge, it's on your thing.
Oh, he's in custody. That's why. Okay, well, I didn't realize that. That makes a difference. Okay. What would you like?
So Judge, we were thinking about getting a trial setting for today. I mean, the state has been generous with their offer. It's no problem with that, but he wants a trial setting.
Yeah, okay. I mean, there's no problem. It's up to you.
Right.
Just whatever day you want. We just need to do at least 30 so that they can get their motions and.
Judge, the state would ask for at least 45 days because he is a Spanish speaker and we.
And I told her.
That takes even longer.
Right, I told her I know,
That
Judge.
takes like 75 days, I think, right? A minimum.
45 days, I believe, is the cutoff for translations that need to be provided to defense counsel.
Have you been able to look at everything?
I have.
I'm sure. Is everything in English or Spanish?
So I think it's in Spanish, some of his, yes, when he's doing his sort of, because he's only really a Spanish speaker.
Right.
Okay.
Whatever day you want. I'm good.
Okay.
Whatever you guys want. Doesn't matter to me. So you guys pick
After
it.
45 days, you're fine.
Right.
Just pick a Tuesday, please. And then
That'll work.
whatever.
Thank you. And Judge, would we, just for logistics, like, would we do it like in the morning normally, or do you do it like after docket?
No, so we do voir dire on a Tuesday.
Oh,
And
okay.
then we start testimony on Wednesday.
Okay,
So
perfect.
everything happens in the morning. So we do voir dire as soon as we get the panel, which is usually around 9:30,
Okay.
9:45. We just go until we pick it, and then we'll start testimony on the following day.
That'll work. Thank you so much. Judge.
Okay. Okay, I wanted to make sure because I didn't know.
Conteste con respeto al juez. Te va a hacer unas cuantas preguntas. Sí, señor, o no, señor, se contesta, ¿ok? ¿Me entendió?
Good morning, Mr. Machado.
Buenos días, señor.
Benitez. Sir, you were charged with driving while intoxicated.
Quedó acusado de manejar ebrio.
You were facing up to 6 months in jail
Una cárcel posible
and or a $2,000 fine.
de $2,000 por los dos.
This is a first, correct?
Es la primera, sí, dice todo.
Any particular reason for 162?
Well, he's been in jail, there's, that's how many,
Days he's just been in.
Esos días que ha estado ya preso, dice.
You have worked out an agreement where they're offering you 162 days in jail, credit for the 54 days that you have done.
Días en la cárcel, pero con crédito por ¿cuánto?
54.
54 días.
es tiempo servido.
You need to understand
Tienes que entender, caballero.
this DWI will go on your record.
Esto, manejar ebrio, lo vas a tener en tu antecedente penal.
It will be on your record for the rest of your life.
Antecedente penal en la lista por el resto de tu vida.
If you ever get pulled over in a car
Te para otro
and you smell like
y
alcohol,
huelen alcohol.
an officer will see a prior DWI.
El oficial va a ver que tienes un
If they smell
antecedente.
alcohol on you, it's probably not going to go well for you.
Probablemente no te
I
va a
would
ir
never get in a car
nunca
if you ever
con un
consume
coche.
any
Si
alcohol.
es con
Do you understand?
el juez, no.
You give up a lot of rights by entering into this agreement.
A muchos
You give up the right to a trial,
de acuerdo.
right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen,
Todos los acusadores, si no eres ciudadano de los
there
Estados
are
Unidos,
possible immigration consequences.
consecuencias del
You can be deported, excluded from the country,
país,
denied naturalization under federal law.
es federal. federales.
You give up the right to appeal.
Rechazando el derecho a apelar este caso también.
You can never change this after today.
Y nunca eso no se va a olvidar después de hoy.
Do you still want to do this?
¿Todavía quieres ir adelante con tu declaración? Al juez, no a mí. Conteste.
Y yo quiero así firmar.
How do you plead?
Just wanna sign.
Guilty or not guilty?
¿Cómo te declaras a este delito? ¿Culpable o no
Culpable.
Guilty.
I'll find you guilty. I am going to suspend your license for 90 days.
La licencia por
I've been
90
taking
días.
license. Good luck to you, sir.
Buena suerte, señor.
Okay. Yeah.
Hi.
Hello, how are you?
Hey. Who do you have?
I have a new case.
Judge, she has on page 38.
Ruby.
Who just pled? Wait a second. Hey, Antonio. He just pled on this case. On Machado?
And I saw someone there, but I didn't know his name.
No. Are you representing a Machado Benitez?
That's right, Judge. Is he the one who just did a plea in front of you?
Yes.
Okay. Well, that's interesting.
Who's that?
This is Miss Naomi Garcia.
Mhm.
Did you get hired on the case?
Yes, he hired me and we did a motion to represent him, but I just got on it and I talked to him already too.
But nobody ever approached him.
Yeah.
So the motion was filed in January, but if no one approaches on it, we don't know. So no one told us to put it in the queue, so I guess it just sat there. And we had appointed him, Antonio, and the guys, it's now at 162 days, so he just wanted to, I guess, get it over with.
Oh, okay. Well, he pled. He claimed he was the passenger in the vehicle, but if he pled guilty, that was his choice.
I mean, if you want to undo it, I can. It's up to you, but that means you'd have to sign on.
Judge, that's okay. I think if he pled and I already spoke to him, he knew that we were coming to court. And if he'd made that choice, then it would, he probably doesn't want to sit there any longer.
I mean,
The reason
theoretically, I have jurisdiction for the next 30 days. If, something, just come back and let us know,
Yes, I will do that. I'd rather not undo it until I talk to him. And then that way I'll know because I don't want him sitting there longer if he doesn't want to undo it.
Judge, although we did discuss, he did claim that he wasn't driving. I explained to him that there's two wheel witnesses that put him behind the wheel. And so.
Okay. I'll let you guys do it. Okay. So
That
just
would-
keep me
that
in the
would
loop
make
if anything needs to be changed, okay?
Thank you. Thank you,
Yes, ma'am.
Benitez.
Okay. Thanks,
Okay,
Antonio.
bye.
All right.
Okay. Take care.
Oh, you know what, Judge? Since I have you, there's another case I need to talk to you about.
Okay.
Sorry, I just looked at my list. Mr. Eric Tome,
Custody or on bond?
he's on bond in ICE custody.
He's in ICE custody?
Yes, he's battling it out over there in ICE custody.
Are you 100% sure?
Yes, so here's the update. I've been giving you updates on this gentleman every 2 weeks. So last time he had an attorney, he was denied an immigration bond, but they started talking about asylum. So he's getting an asylum application that's pending or about to be submitted. He's gonna have court on March 19th.
Okay.
So we should have word from immigration on March 19th.
Okay. But you've been able to verify it's still in ICE custody?
Yeah, okay. Look him up again.
I'm
now.
okay with the reset then.
Yeah, okay, so after that date. Okay, perfect, thank you. Yeah, he's in ICE custody, he's got a hearing date and everything. All right. Hey, this is Mr.
Good morning, Mr. Jackson.
Good morning, sir.
Jackson, your lawyer's asking for me to set you a bond. I don't know. The only thing I know is that you're wanted out of another jurisdiction. I don't even know for what. I don't know if I'm going to set you a bond, but two things are very clear that I need to know. Number one, if we set you a bond, are you going to go back? And number two, if we set you a bond, are you going to be a danger to our city? Because that's my primary concern. I want to keep my streets as safe as I can.
Yes, sir.
Do you understand?
Yes, sir.
I know that you're going to tell me it's lollipops and gumdrops and rainbows and this and that, but I have to get you in a very short, I have to get to know you in a very short amount of time. And the way I get to know you is how you look on paper, because that tells me really who you are. With that, let us know about Mr. Jackson.
He's wanted out of Greenfield County, Colorado for failure to appear for burglary. The bond over there is $50,000. This was a case out of this was issued out of 2023, October.
So has he been on bond?
No.
Did he know that it was out there? Is it a to be?
The failure to appear.
Oh, failure to appear. So he knows that this has been open for the last 2 years.
Yes, Judge. State's opposed to a bond as well. Of course, as the court knows, he has an evading with a motor vehicle out of the 209.
No. What?
Yes.
He has an open evading as well in a motor vehicle.
Yes, he's got a case pending here in Harris County as well. Invading, that's right.
What are the criminal history, if any?
His other recent one was from 2022. He had a theft, which was a state jail. He was given, I believe, a deferred, and it was revoked in 2023.
Wait a second. So you're telling me that that case has been open, it's been in a warrant status since 2023, and he was able to get on a felony probation in 24 here while that case is open over there?
Looks like it.
The case that I caught.
Yeah, so that one was filed in 2022, and then they revoked it in 2023, October.
The reason why I got the warrant is because they took me in custody.
Something doesn't add up.
But I made it to all my courts. I never missed a court date before this.
Okay, in Colorado is what you're talking about?
Yes, sir.
Okay, understood.
Yeah.
Judge, so there was some back and forth on when he got taken into custody for the last case. He's saying that he didn't miss a court date because he was in custody at that point. And so there's a lot of back and forth. The situation I'm talking to him about is, hey, judge is going to say you've had this case pending since this time. He has a plan in place to go to Colorado. What's different is that he now has a daughter that is 2 years old. So he's trying to do right by her, and so that puts more responsibility on him. He does have the evading case, but he would like to see if he could get a bond here, because the trouble he's getting is people aren't allowing him to post the other bond because of this fugitive case. And so it's kind of which one comes first, and we're hoping you could give him.
The thing is that case has been open. Are you telling me it's been in warrant status for 2 years, Amy?
Yeah, the Colorado case is from 2023.
He's known about this thing. It's been open for 2 years, yet he's never done anything to go back to try to rectify the situation. Now, because he's arrested, now he's all ready to go.
Well, the difference is now he's got his daughter, and and so he's growing up fast.
Jackson, I can't trust you to do the right thing. You've had 2 years.
Yeah, no. At first, I ain't have no money to go out there.
That's a good point I mentioned before. Yeah. He is also mentioning to me his finances, whether his finances were back then. He was 19 at that age. His finances are a little better now. He's got the support of his wife, I believe, or his girlfriend.
My girlfriend.
I don't.
And also, Harris County been putting me in and out of jail since I've been incarcerated in Harris County since then. So I really ain't have no chance to go out there. I only been inside the world for like a month and a half, almost 2 months.
Okay. Judge, we're not asking for a PR bond. We're just asking for a bond enough to ensure for him to go out there and turn himself in. He still needs to make the bond. And so this would at least put something in place where he can make this bond and make the other bond. And if that doesn't happen, if he can't do that other bond, I'll reapproach and we'll pull.
Here's the thing, Mr. Jackson. I appreciate the argument that you guys are making. I truly do. But the fact remains is that case has been open for 2 years. And to say that money has become an issue, I just don't, I don't believe it. And the thing is that you've had a long time to be able to do the right thing, to go take care of that. And yet in between that time, you're still picking up criminal cases here and it's still, nothing's happening. I feel if I were to give you a bond, I don't think that you would go back. I just don't want you to pick up another case. I don't want more harm to come. I'm sorry, man. I'm not going to do it.
Would you reconsider if he does make the other bond first?
No. But the point is that you've had 2 years to get and do the right thing. And no matter how much time that you've come.
If it's about the bond, go ahead. If it's about the bond, don't talk about this case in specific, but go ahead.
They had,
Talk to the judge.
okay, Judge, during them 2 years, I ain't gonna lie, I've been incarcerated 2 times. The first time, I would have never missed court, but they took me in a day before my court date. That's the whole reason of me having a warrant. And when they took me in, that's what slowed me down on a lot. I had my daughter, my mother got cancer right now. I ain't gonna lie, like, I don't know, like,
It's always the right time to do what is right. You
Yes,
know who
sir.
said that?
Yes, sir.
Right. You know, you've had 2 years to get it done right. You've
I
not been incarcerated
had-
fully for 2 years. You know, now all of a sudden,
Out of them
because you're
2
in
years, sir,
custody,
I only had 6 months out of 2 years, sir.
I'm not going to argue with you.
Yes, sir.
I've got to understand that at some point,
Yes, sir.
we cannot just continue to, no, it's time now to face it. I can't just continue to let you out and trust that you're going to do the right thing. You've had that opportunity over and over and over. And yet, after 2 years, you still haven't had the wherewithal to get it done. Why is that going to change now? I don't think it will. You know what I mean? Actions speak louder than words. And I hope that you remember this in the future so that if you do have something else elsewhere, take care of it, because that warrant will always be there forever and a day until you take care of it. You know what I mean? Okay.
All right, thanks, Judge. Appreciate it.
Up to the bar, Mr. White. Okay. Is he on docket today or no?
This case is on docket, yes, Judge.
I see.
And he's got another case, another open case.
Whoa. Whoa.
And that's an assault family member. This one is a terroristic threat, his current case.
He's on bond for an assault and he just picked up a terroristic threat.
Yes, Judge.
You are facing up to a year in jail and or a $4,000 fine on your new terroristic threat of a family or a household member. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Yes, Judge. On February 18th, 2025, in Harris County, Texas, the officer was dispatched to a family disturbance. The officer met with the complainant, who stated that the defendant had been threatening her. The complainant stated that she and the defendant had been arguing all day, and that the defendant stated he would stab her and throw her down the stairs. The defendant stated he would shoot her, and then the defendant showed the complainant a large hunting knife, and that's when the complainant advised that she feared for her life.
Who is the complaining witness in this case? Same as in his open assault?
No, Your Honor, they're a different complainant.
Mr. White, I'm going to find that there's probable cause to go forward with your case on the new terroristic threat. I asked you one thing, sir. I asked you not to become a danger to my community and not to pick up a new case. You now have. I will now revoke your bond in the assault case. It goes with you. $5,001 for the assault, please. I am now issuing another protective order on this person. You know, is there a protective order that's open in the first assault? No? Because if so, we could be looking at a violation of protective. I'm issuing a protective order that identifies Farah as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Mr. White, let me be clear with you now. I will do everything in my power to protect my community at all costs. You pick up a third case, I'm going to go absolutely bonkers. Do you understand?
Yes, sir.
You are not to smoke, use any kind of illegal substances, consume alcohol. I'm going to test you, and I'm going to put a GPS monitor on your ankle prior to release, please, so I know where you are at all times. And I don't want you anywhere near any of these complaining witnesses at any time. Do you understand?
Yes, sir.
Okay? Because if you, we need to sign them all.
Give me Sunday on that street, 218, right at the bottom.
Oh.
Like the last one.
Okay, all right.
And they still judge the previous case, you want that one on the road to 501?
Yeah. The assault case,
How much, Judge?
5,001.
5,000, Judge?
5,001.
5,001.
Yeah.
Thank you, Judge.
Thank you. Mr. D.
What is the difference between a PR bond, personal recognizance, and a regular cash bond? Which one do you think is harder to earn from a judge?
Mr. D.
Yes, ma'am. Young Mr. Yale Serato could not get to court. His mom's car broke down. I approached, he raised his bond to 5,000 and notified the family and told us. And he insisted that he was coming down today. So he is here today, Judge. We have a 1-year defer worked out with the.
Come up, Mr. Serato. Man, he couldn't even get to court. How's this dude gonna work a probation then?
His mom is behind him. He's got it's 16 hours of community service, which he knows he can get to do. He has 2 online classes and he has to write some letters of apology. He knows that this is his chance to keep this off his record. I've talked to his mom. They are behind him. They're going to help him do this, Judge.
Give
him a chance, sir. He can do it. Right, Yale?
Yes.
We have at least 3 times you couldn't make it to court. Just to even come to court. How on earth are you going to be able to make a probation? You couldn't even come to court.
Well, for some of them, it wasn't entirely my fault. For one of them, I came to court, but mostly when I'm anxious, I get sick, and I had like a huge headache, and I ended up getting food diarrhea because of it, so I couldn't come. So I had food poisoning for maybe 3 weeks. I couldn't control that, so I'm sorry about that. For yesterday, my mom paid the insurance, and it's expensive, so we didn't have any money until today because my dad got paid today. So we couldn't even get family members either because they live far away. So if they came here, I would have probably came here around like 10 or
So
11.
you have all these issues now. You realize you get on this probation. There's no excuse why you can't go to probation. There's no excuse why you can't do your community service. There's no excuse why you can't do your classes. If you don't, you're looking at an entire year in jail. This is not a joke. So you either do it the right way or you end up in jail for up to a year. But, in life, you have to act a certain way we do things, right? You're expected to behave in a certain way. And when you don't, there are serious consequences. I had given you multiple chances to try to get here. I worked with John to try to get you here. And this last time was the 3rd time that either the car broke down or, that was the last 3 excuses where the car broke down. That's why, to me, that's unbelievable. And I'm not going to accept that my car broke down for a failure for you to complete your community service on time. Do you understand, Mr. Serrato?
Yes, sir.
This is a very big deal right now because I want you to understand something. When you end up with an assault on your record, it closes very many doors. Because when you try to get a job and if someone sees that you have an assault on your record, what do you think they're going to do? What's that?
Decline.
Right. Because they know that if you get into a potentially stressful situation, something might happen. And they don't want that kind of liability. John has worked out an agreement where it's a probation, where if you do a couple things, you don't end up with a conviction on your record. But this is not a joke to where, oh, I can't make it to community service because my car broke down. I'm not going to entertain that excuse. Do you understand that?
Yes, Judge.
Can we hold the probation here? Or is it too difficult to do that? It's too hard. It's okay. Did you graduate from high school?
Not yet, sir.
He's at Eisenhower right now, Judge. He's still going to school. We have to get
Are
him
you
a pass.
actively enrolled in school now?
Yes.
Okay. I want proof that you're actively enrolled, and I want, what are we now? What, February? So it's, oh yeah, there's still school. I want a week to bring proof that you're enrolled in full-time in school. That is a part of your condition as well, that you graduate from high school.
Yes,
Do you understand?
Yes, sir.
You're not to consume alcohol or illegal drugs. If I find that you're smoking weed, I will issue a warrant for your arrest. I'm going to put you in. You're looking at up to a year in jail, but I'm not going to let you go. At a minimum, until you graduate from high school. You will be with me until you graduate from high school. Do you understand?
Yes, Judge.
Are you a junior or a senior?
A junior.
Wonderful. You will be with me for the next until you graduate, because that is now a condition as well. An effective decision-making class, a 2-hour anger management class, no drugs, no alcohol, 16 hours of community service. As long as you're enrolled in high school, then I will waive the community service. There's no need for you as long as you're in school and studying and doing well. Failing does not equate to being enrolled in school. Failing does not count. At least a C average. Do you understand?
Yes, Judge.
An apology letter to the complaining witness in this case. If you violate this probation, I'm going to issue a warrant for your arrest. I'm going to put you in jail. We will have a hearing to determine whether you violated the probation. I can either extend you or keep you in custody. I want you to know that this is not a joke. Do you understand?
Sure.
There is also an affirmative finding of family violence, meaning that you ever pick up on one of these cases again, you will be looking at a 3rd-degree felony, 2 to 10 in the penitentiary. Do you understand?
Yes, sir.
You can never own a gun or ammunition as a result of this as well. Do you understand?
Yes, sir.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. You know what the consequence is if you violate this probation. Everything must be done on time. You have a certain amount of time to get things done. If you don't, you are in violation of this probation. If you pick up a new case, you're in violation of this probation. Do you understand?
Yes, Judge.
Okay, so let's have him drug tested in 2 weeks, please. And then I guess let's do both. So in 2 weeks, do confirmation of enrollment and a drug test. How do you plead to the offense, Mr. Serrato? Guilty or not guilty?
Guilty.
I'm not going to find you guilty. it would probably be best for you to make this thing work out because you could really lose big if you don't. It's not about the money. It's never about the money. I don't care about the money. I'm going to waive every fee that I can on you. It's never about the money. I don't give a rat's behind about it. I just want you to do what you say you're going to do, and I don't want you to smoke marijuana. Do you understand?
Yes, sir.
Do you have any questions?
No, sir.
All right. Good luck to you, sir.
Thank you.
Thank you, Judge. We're gonna talk to this lovely lady.
How are you, Judge?
Hey.
I also have a motion to sub.
Okay, I'll sign it.
But I did want to approach you on that specific case, Judge.
On who?
The motion to sub that I filed.
Okay.
Marcano Garcia, here's the case number. 2419896.
Thank you.
Marcano Garcia?
Yes, Judge. So he's in warrant status right now. You forfeited his bond a while back. So what he explained, I talked to his family. What they explained to me is that he was offered like a retail theft program.
He took off 4 different times, and I literally bent over backwards not to issue the warrant. Is he not here?
He's not present today. So I want to talk to you first before I bring him in here, to see if Your Honor would allow us to do a walkthrough.
4 different times.
So I don't know the history of what happened, Judge, but all I know, let me explain, Judge. So I've got phone records, text message, screenshots of him trying to get a hold of the prior attorney. I don't want to name names.
Don't, right.
But I've got, like, I can show you this, I can show you the text message string where he's asking, when's my next court date? What am I supposed to do? When's my next court date? What am I supposed to do? When's my next court date? And there's no response. Then later on, it's like, okay, what happened? Oh, you got a warrant now. You got to come to court. It's like, wait a minute. Why do I have a warrant? What did I do wrong, or what's supposed to happen here?
I know that people say things.
Not
All
saying
I know,
things, but
you're an officer of the court. I trust you. All I know is that we've got 4 different times he's not appeared. We've had defense over here saying, hey, man, I can't get a hold of him.
Okay, so I
don't know.
The other defense loss officer of the court, but that is not in line with all the text message strings that I've got showing, when's my next court date? What am I supposed to do? When's my next court date? What am I supposed to do? I did speak to the state yesterday about this case. They are willing to leave that retail theft offer open. My concern, Your Honor, is that obviously if he goes into custody, immigration is going to pick him up.
Sure.
And the only reason that I've got a hold of, or that he contacted me, is because I represented his wife on a separate incident, which is what confused me a little bit too, because I represented her after the fact, after his case was already in bond forfeiture status, but he was unaware that it was in bond forfeiture status because he kept trying to get a hold of the prior attorney to figure out what we could
Blaze,
do.
what say you on this case? Did you hear anything?
I'm trying to, sorry, what was the case?
Let him know so I can see what he, I'd like his opinion, what he thinks.
The
problem is that the case is 3 years old,
Right, I think it was filed in 2022, if I'm not mistaken. And
I've got
like
literally
prior retail theft was offered already, Judge, and
I mean, that's speaking to
done.
No, not
whatever you need, just tell her.
That's he can do it. He's willing to do it. He was
please.
Apparently prior attorney did not communicate with him next court dates. Again, I could show you the text message strings, Judge.
Show Blaze.
So these are from January 3rd, 2023. January 16, January 17, January 17, January 19, January 30th. So for a whole month, no response. Then whatever date this would be, it just says OI, but I'm not sure what OI means.
I'm live streaming, so don't. That's why. What do you think, Blaze?
Then again, January 30th, February 26th, February 27th, finally on February 27th, a response. That's 2 months, Judge. That's 60 days.
Yeah, I can see it. The only thing I would say is there a reset? I mean, did he have a case reset more?
That I don't know, because it looks like some of this stuff might have been off.
I have here on, so it gets reset 1/24/23 to 2/28, and for that 228 setting, I tell the council that defendant's got to be here on 228. I'm assuming it gets reset 228. Let me see.
I'm trying to link up the.
I mean, January 3rd, I'm assuming he was not supposed to be here on that January 20 whatever date that you said, Judge. Then it was reset to January 20.
No, so for the January,
which would have been
the January, his appearance was waived. But then for the February setting, his appearance was required.
And Your Honor, I'm showing the text messages where he's trying to figure out, what do I do? What's the next step? It's not until February 27th, the day after the court date, when he was supposed to be here, that he's notified. And he says, no tienes que ir a la corte hoy. You don't have to be there. February 27th.
Wait, say that. Is he asking or is he saying?
February 26th, what do I do? What do I do? The whole month, 2 months before that, what do I do? What's the next step? What do I do? What's the next step? February 27th, no response. This is the text message that he sent back.
Spanish, so I don't know.
It says ninguna respuesta. I'm assuming that this attorney is
no response.
I'm assuming that this attorney is talking about the response from the DA's office. That he was trying to figure something out. No response from the DA's office. ¿Estás en corte? Question mark. No tienes que ir hoy a corte.
So do I have to come to court today?
And he told them affirmatively, no tienes que ir a corte.
He said that?
Yeah.
What day is that?
This is February 27th, 2023 at 8:21 in the morning.
That's not right. Right. Okay.
So, and he wants to take care of the situation, Judge. If we can either reinstate his.
You're okay with continuing the retail?
We're fine with that.
What needs to get done?
It's basically just,
Like a class in Swiss, I'm assuming.
Never assume.
it was the retail theft, which is, yes, class dismissed. But.
Good assumption.
I just say get it done.
So let's put a time limit on it though. So I'll reinstate it.
Thank you, Judge.
Now, you're in good contact with him, right?
Yes, yeah, I'm
Okay.
in contact with his wife.
I'll just reinstate it. There's no need for him to come.
Thank you, Judge.
And then just let him know about the class.
Yeah.
Give him 2 weeks.
Like an 8-hour class or whatever.
Shoplifting thing.
Okay.
Are you ready?
Yep.
241-9896.
So the class is
The
dismissed.
judge should consider personal circumstances like family, employment, or age when making decisions in court? Or should every case be treated exactly the same way?
So the class is dismissed.
Through the HCDAO website, right?
Yeah, so
How much time are you?
2 weeks.
2 weeks.
If it's not done, he's got to be here. I'm setting him for trial.
Perfect.
Whoa,
How are you?
whoa. I mean, it's only been like 3 years,
I know, sorry, I
you
stuck
know?
upstairs most of the time. How are you?
Hey, what's up?
So I have a client who I represented upstairs.
What's your cause number?
The cause number in your court, Judge, is 2506241.
Wow.
It's actually already resolved here. He was taken into custody upstairs on 220 for a capias here.
Yeah.
Um,
So here's what happened. We had so many issues with this guy, not appearing, testing positive. He probably had 3 to 4 BVRs, right? And I told him, look, it's a second, you know, I think he even bond forfeited and he came in, he just wanted to, I guess, flee. And he had the supervisory fee, said, okay, I'm going to pay it. And I said, okay, I'm going to give you 2 years. He just didn't do anything. And then he picked up a DWI third, and then he gets up on probation on that thing.
Mhm.
I think he's now serving out that time.
yeah, okay. So I was unaware of all that. He obviously indicated to me that he didn't know anything about a 6,000 because I just looked at the initial plea paperwork and there wasn't a fine because I had never seen that. But at the very bottom, I did notice at the very, very bottom of the judgment, which he wouldn't have gotten
They sign paperwork
this.
to that fact. Hold on.
Didn't have it
Let me
on.
make sure I'm right before I tell you something that's wrong.
The plea paperwork did not have it on there. I pulled up the plea paperwork.
No, because it's usually not on there. It becomes part of the, I don't even know, how does it, yeah.
If it's probation, is it probation?
It wasn't
or
probation.
Conditions of his time?
No,
He took a straight plea.
yeah. I think what the thing is they're supposed to do is that when they get out, at that point, they're supposed to go to enter collections to do a payment plan, and he never did.
Again, I don't know what can be done at this point. I just told him I would come down here just to check, because he said he never knew where to go. He was never told about a payment plan.
I told him.
I believe.
Yeah, I'm telling you because we had a lot of issues with
I know,
this
I
guy.
mean, but
He's had, here, let me tell you. I'll show you.
Oh, I know. I know. Yeah.
You obviously represented him upstairs?
I did. I mean, and of course, he pled up there. He's on a probation. Well, he just pled on the 21st. He's sitting out his 10 days up there. But I would just told him I would try to follow up here to make sure.
Prior to?
I'm sorry?
Did you have him TRAS prior?
He did not, and he knows that he may end up going to inpatient, and he needs it. And that's what, and we,
I mean,
and he and I had a heart to heart about needing the inpatient and mental health. He's got mental health issues too. I anticipate he'd probably go to, that he'll probably be recommended to DDRP is what I anticipate would happen. Just me knowing his mental health and the situation, because upstairs, it's definitely not alcohol, it's PCP. So I don't know if it was alcohol or anything down here.
Jeannie, has he done the TRAS yet? No.
No, Judge. He's sitting out his 10 days right now because he pled on the 21st. He was taken in on the 20th for the warrant. And then we pled him on the 21st. I just carried him over.
You know when it's set?
I don't know.
Alex, can you check it, please?
For which, Your Honor?
For the felony case?
I don't know if they would schedule him for him until he's out for his 10 days, to be honest with you.
No, but they'll do it in. I'm surprised that they wouldn't schedule him to do it in now.
I don't think so. I think because they just don't know what, because he only has the 10 days, and I know that they're not being scheduled that quick in custody. He has the 10 days on that case up there, and was technically on bond upstairs. You know what I mean? So I think that they haven't scheduled it. They would probably wait to schedule it once he's out, is what I anticipate. But he does know that it's likely he would be recommended for inpatient, and he knows he would have to go back in for that. But I don't know how long he would be staying in for a $6,000. You know what I mean? I don't know. Do they get credit for that toward jail time?
I warned him like 15 times. You know, the crazy thing is that he picks up a DWI nearly not even a month later, like 2.5 weeks later, he picks up a felony DWI. I mean, and it's number 4. What do you want me to do?
Well, I guess my question is on that particular find, does he just sit out that whole, does that work the same way as it would if you were fined?
You just sit out the $6,000.
Every 100 days. Every day is $100.
Is it really? That helps sit down? Yeah. I mean, that's what I always thought.
That's what I was told for the sheriffs.
I said the fine was in the same category because that's the DPS mandatory fine, right? Isn't that what that one was?
That would probably be a question with the sheriffs and how they handle it with the 3-for-1 and the $100.
Yeah, I don't know either.
We just
Does he-
put for man so satisfied.
Okay. Well, I guess
I can try to find out for you if you want to come back tomorrow.
if you don't mind.
I'll try to find out for you.
It's the first time that I've seen that fine, and then someone obviously have to, because usually when you would, not you specifically, but we would do that form to waive it, but.
There are very few times that I hold people actually to it, but usually ones that have so many issues that just refuse to comply in any realm whatsoever, then I mean, I can count on one hand, right?
Right, yeah, they're not.
But Mr. Bryant is one of those people. It scares me. He truly does. I mean, and I'm surprised that you guys didn't do the TRAS beforehand so he would get knowledge, because when you get out and then you do the TRAS and then they're telling you to go back in for an 18-month or 15-month program, inpatient.
Well, he was admonished to, so, but yeah.
I know. And it's always easy to say, you know?
Yeah.
So, all right, give me some time and I'll find out. For
Because,
you.
I'll check back in tomorrow if you don't mind, Judge.
Yeah, absolutely.
Because if he is going to be there for 600 days or whatever, or 60 days, not 600, but 60 days, yeah, then I'll see if they'll just go ahead and do the TRAS, knowing that he's going to be in there that long. But if not, then I'll figure that out.
No, tomorrow.
Okay, great. Thank you, Judge.
Ryan Rivas.
Okay.
We have a bond violation report.
Come up, Mr. Rivas.
Mr. Rivas also has a felony. That case was dismissed today, so we just have our misdemeanors now.
What am I supposed to do, Mr. Rivas? Over and over and over. I ordered you not to use any illegal substances, and yet it continues to happen. No, I mean, what? Felicia, when was the first test that we did on Mr. Rivas?
My last test was the test I took.
Did you represent him on the aggravated assault?
No, I didn't, Judge. He was just appointed an attorney this morning up there, and the case was dismissed the same day that he was appointed an attorney. Who was the attorney appointed?
Mr. Andrew Williams.
Andrew Williams. But I'm sure you know what he's going to say. He said he was trying to explain to you that the marijuana was in his system from when he was arrested on January 22nd.
Yeah.
Judge, the only test we have is from the 18th.
What day?
Uh,
You mean today?
No, the 18th, February 18th.
Okay, that's,
I just took a test last week. That was my
And
first
that's what
test.
the,
you've been on bond in this case since September. Since September, you've known not to use any illegal substances. It's now February. What possible excuse could there be?
There is no excuse, Judge, given that
He has 3 open cases with us. I mean, I've continually told you not to use.
I think one of those cases was possession of marijuana. And he said that's the day that he used, the day that he was arrested for possession of marijuana.
September 28th.
Yeah.
Sorry. Goes with you. I don't know what to tell you, Mr. Rivas. You're not getting it. I'm telling you, no using.
Can you give me another chance? My first test. This Friday I have a college for UTI, which I paid $200 for. I can show you proof. I have an email of UTI. I've been changed. I've been trying to change. I told the door upstairs too. I haven't smoked since I got out. I'm an ankle monitor. I haven't smoked since I got put in this ankle monitor, Judge. You can.
When you get that ankle monitor?
Took me on the day I got released from jail.
whether he checked in for the drug test on the 18th, he did state to us that it.
You got the ankle monitor on the 18th? So you tell me you stopped smoking 2 days ago?
No. Sorry, that's when he told us he had consumed marijuana in about 2 to 3 weeks from the 18th. And then the ankle.
So 2 to 3 weeks ago, you're telling me he says he stopped?
No, I stopped since I got out of jail.
January 22nd, Judge.
That's the day I stopped. I enrolled in college now, which I paid $200.
That was the last arrest because these cases were
If
different.
it's January 22nd, it's been 1, 2, 3, 4 weeks and 3 days, 4 days.
Judge, but I know I can change, Judge. I've been trying to better myself since I got put in this ankle monitor. I've been in jail. I don't want to be.
Yes, it's from January 27th or January 28th.
January, what day? Exactly.
They entered it on the 28th, but I don't believe he got it until sorry, they entered it on the 27th. I don't believe he got it.
What was the absolute last day?
The day I got arrested for the aggravated for this charge, this case that I got dismissed, I was parked in the car. That's when they had me. That's the last time I smoked.
December 19th, I see as the date of arrest. Or are you telling me the time you stopped was the time they put the ankle monitor on you?
So
tell me, Mr. Clay.
The December 19th is when that felony was filed. He wasn't arrested on that felony until January 22nd. And he's
Okay.
saying that's the last time he smoked. When he got out on bond for that case was January 27th. He was given an ankle monitor as part of
Yes,
the
he was
felony
given an
release.
ankle monitor in the jail on the 27th.
And I haven't smoked ever since. I'm trying to change.
All right. then I'm going to give you the benefit of the doubt. Then I'm going to calculate it from the 27th and on to give you the benefit of the doubt. I will test you again 40 days from that day, 45 days. If I find that you test positive again for marijuana, it's not going to go well for you. If you're lying to me, it's not going to go well. Do you understand?
Yes, sir.
Do not use. Do not hang around with people who are using, because I don't give a rat's behind if you tell me you're in a car and everybody else is hotboxing it. I don't care. Do you understand?
Yes, sir.
If you're really working this hard to better your life, which is really commendable, right?
I just got a job. Now I just enrolled into UTI, which I had proof my Gmail, which is this Friday. I have a touring class, and then I have in tour in the.
Then don't muck it up by hanging with the wrong people. I bet all the cases that you have now. You speak Spanish?
Yes, sir.
Dime con quién andas, yo te digo quién eres. You understand?
Yes, sir.
All right, Felicia, we know what it is. Okay? All right, Mr.
Thank you,
Glegg.
Judge.
All right, man. Make me proud. I'm not asking for much. Don't use, but don't put yourself into a position when you're hanging around with bad folk.
Yes, sir.
All right.
Thank you.
Judge, your fabulous coordinator, NCLO.
Mr. Quell, IER, GH, 8 and 9.
Come on up, Mr. Ghani. Damn, 12:30 already? Mr. Ghani, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow, so you were facing up to a year in jail and or a $4,000 fine. It's actually a DWI second that's being reduced to a first. So that's 2 DWIs on your record. What happens on the next one?
Jail.
Nope.
Fine.
Again.
Prison.
Right. Do you have any clue what they would do to you in prison? I've read stuff it'll turn you white. It's so bad. I read that had me freaking tears because it's so bad. That's how bad it is. Really. There's some parts of the prison, they're so bad that jailers won't even go into it because it's so bad. That's how bad it is. And all you need is just to have the faintest smell of alcohol, because when you get pulled over next time, because it's going to happen, officers, all they look at is your record. And if they see your record and they smell even the faintest smell, you understand. If I were you, even if you've had a sip of alcohol, I would never get into a car. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, it can never changes. Do you understand? For you to complete this successfully, it is 1 year in Harris County Jail to be probated for 18 months. You must do a repeat offender DWI education class. 2 victim impact panels. You will also do a TRAS, which is an evaluation to see what other conditions you may need. If they assess other conditions, you must fulfill them. Substance abuse treatment. No drugs, alcohol, guardian interlock, 25 hours of community service, and a $100 donation to the Houston Area Women's Center. Is this how you understand the agreement?
Yes.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this probation and once you plead guilty, it will go on your record. It will be there for the rest of your life. Do you understand? There is also a no breath test refusal clause as well, meaning that if you're pulled over in a car, an officer asks you to submit a breath test, you must do it. If you don't, you're in violation of this probation. Do you understand? there is a supervisory fee that you will be required to pay with regard to this. And if you don't pay it, you will sit 1 day in jail for every $100 you owe. Because it's a 0.15 or above, it is a $4,500 surcharge that you're going to be required to pay. And if you don't pay it, you'll be sitting in jail for a long time. Do you understand? All right, sir, I'm going to follow the agreement, send you to it. Good luck to you.
Your Honor, with the court commissioner waiving his fees, he's lost his job. His mom was the one that was paying.
I don't know that for sure. All I know, it's a DWI second. I mean, we warned him. So, I mean, I'm going to give you enough time to pay. Okay. We will give you 2 years to pay. You know, it's never about the money as far as probation is concerned, though. You know, if you ever have problems, come back, we can talk to you. But you must get a job. I don't know, you know. I mean, I can have you fill out an affidavit. We'll see what your financial situation is, but I want you to pay the fee. You know, I want you to learn so you don't pick up another one. I have someone that's sitting in there right now. Same thing. They're sitting out $6,000 something dollars, you know. It's not a joke. Take it seriously. Do you understand? All right. Good luck.
Thank you, Your Honor. I also have a motion to withdraw Mr. Nathan Fuller, Your Honor. He's a bond forfeiture.
Say it again.
I have a motion to withdraw from Mr. Nathan Fuller.
Okay.
Whose paper?
I see it.
I haven't heard from him, Your Honor.
Was he required to be here today?
Yes, Your Honor.
Okay. I'll grant it and then I'll revoke it.
Thank you, Your Honor.
Okay. Thanks, Mike. Tell me when you're ready.
All right.
254-7447.
Thank you.
Mr. Merritt, you were charged with criminal trespass.
Yeah, no, I didn't know. I didn't know what they did. I went down there to where I go to the medical Casa de Amigo, and I got there early.
Hold on. You have the right to remain silent. You have the right to remain silent.
Yeah.
Exercise that
Okay,
right.
okay.
Because I don't want you to say something that's going to hurt your case.
Yes,
Okay? All I know is that your bond is at $5,002 because you've missed court a couple times. But we're glad that you're here now. You need a hearing aid, man. I don't know how much louder I can talk.
I can't hardly hear at all.
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Okay.
Would you like me to appoint you a lawyer? You need one. Is that okay?
I didn't know I was even breaking the law.
Well, let's see. Please.
Yes, Judge.
Speak loud.
Yes, Judge. On January 13th, 2025, at 814 Crosby Street, the Boys and Girls Club, the complainant stated he has asked the defendant to leave 10 times in the past, and officers have warned the defendant to leave the property in the past as well. The defendant refused to leave the property after being told multiple times on January 13th. The complainant called the police, and the officer observed the defendant on the property and detained him.
Was it that one day he was there?
He was there on the 13th of January, and the complainant said that they had warned him 10 times in the past not to return to that location.
Okay. Mr. Merritt, I'm going to find that there's probable cause to go forward with your case. Do not go back to the boy. What is it?
I don't go back over there. As soon as they did that, they've never told me nothing. The only reason I go there is for medical help.
Okay. You're going to have to find a new place.
Somebody lying right there.
Okay. Perhaps
Said that.
like LBJ Hospital or something of this
Okay.
nature. I will give you a lawyer today.
I'll stay away from them, believe me.
I
don't need any kind of trouble.
Please. I'm going to have to reset your case to give you time to work it out with your lawyer. Okay? I'm going to need you to come back at least one more time so you guys can talk about it.
Okay, sure.
Okay? So if you just want to take a seat, I'll have you speak to a lawyer here momentarily.
Sure.
Okay?
Come up to where?
Have a seat.
I'll have a lawyer talk to you.
Sure.
Okay, please.
Man, I'll get my own lawyer passing.
Let me give you one.
Yes, sir.
What you just watched was a real morning session inside an American misdemeanor courtroom, and it gives us a rare, unfiltered look at how the justice system actually operates on a daily basis. Most people's idea of a courtroom comes from movies or TV, dramatic trials, big speeches, and clear-cut verdicts. But the reality, as you saw today, is very different. The majority of what a judge does every single day is not dramatic at all. It is case management, reviewing charges, setting conditions, hearing from attorneys, and making fast decisions that still carry enormous consequences for real people's lives. What stood out in this session is the human element of justice. A judge is not simply a machine applying rules. They are reading people, listening to history, weighing risk, and making judgment calls. They must protect the community while also giving individuals a genuine chance to correct their path. That balance is not easy, and it is never perfect. We also saw how important the right to legal representation truly is. Attorneys in this courtroom were not just arguing. They were negotiating, advocating, explaining circumstances, and sometimes being the only reason a person got a second chance or a fair hearing. The American legal system, like any system, has its flaws. But what this video shows is that at the ground level, there are real people working every day to make it function. Judges, attorneys, coordinators, and officers, all trying to deliver something that is both fair and just. Understanding how that process works makes all of us better informed citizens, no matter where in the world we are watching from.